Some concern lately about the law and the issue of text messaging and the law. Well, I've been practicing law for 36 years, and I'm also the CEO of Text2Drive, and I want to share with you what the law really is and how this has become such a big question mark in a lot of dealers' minds. It all began really in December of 2011 when the Automotive News printed a story involving Lithia Motors and a group of citizens or consumers from Washington, Oregon who had filed a class action suit against Lithia Motors. Involved in the actual case itself was also DME, which is a large company out of Florida owned by the Jim Moran Group. Lithia had contracted DME to send tens of thousands of text messages to customers that involved the sale of Lithia vehicles for only 0% financing or 0% financing. You can see it on the screen yourself. Regardless, 60,000 people were sent this text message. It's called text marketing. The message was sent, and at the end of the message was the requisite reply stop to opt out, which is important in all messages sent to consumers. But what happened was this: 8 days later, Lithia sent a message again to 48,000 consumers. This message did not contain the requisite reply stop to stop, and the message was sent out, but the problem was this: all the people who had replied stop to the first message got the second message also. And that's because whatever system DME was using was not set up properly, was not created properly, and they did not know how to use it properly, and therefore they got themselves and their client into a serious, serious problem. So in handling text messages, it's important that you engage a company that's experienced in it. One thing about Text2Drive, we've been doing this for 5 years. And the fact that the CEO, that's me, of the company, is also an attorney, should give any dealer a lot more confidence that what we do is legally acceptable, and that if anyone is going to protect them and my own business, it's going to be me. So let me explain to you where the problem begins and how there are two separate issues involving text messaging. Now, the Lithia issue and many other issues which have involved lawsuits involve text marketing. That is, sending mass messages to consumers who probably haven't even opted into any text campaign and probably haven't given you permission to send them marketing. That issue is controlled by something called the Telephone Consumer Protection Act, TCPA. It was passed or enacted by Congress in the early 1990s, and it was because there were companies that were sending out mass robocall type messages to consumers' landline phones, including hospitals, and they were literally tying up lines of businesses that couldn't even make calls because all these robocalls were coming in. So the government put an end to this and said you can't send or call people, using automated systems without their express permission to receive such a call. But what they've done recently, they've used that, particularly the Ninth Circuit, which is an extremely liberal circuit, the one that's in California, has used that to say that text messages are going to be governed by the same set of rules. But again, keep in mind this is all about messaging. Text2Drive engage in something called transactional messaging, and it makes a world of difference. Transactional messaging is not covered by the TCPA. There is no law regarding that, and it makes perfect common sense. If you're facilitating a conversation, that is, you're telling somebody their car is ready to pick up, you're letting them know they have an appointment tomorrow, you're telling them or asking them to call back because you need authorization, letting them know they missed an appointment. These are all issues involving facilitating a transaction which is already in the works or about to take place. Transactional communications are not covered by the TCPA, and therefore it is not in any violation of any law anywhere to let people know their car is ready for pickup, they need authorization, a tech is looking at your car, a number of messages which involve true one-on-one transactional communication. Now, like I said earlier, when you start sending out tens of thousands of messages to people and don't have opt-ins from them, that's a problem. On the sales side of Text2Drive, when a customer texts into a dealership with a stock number, the dealership name, anything involving a customer sending a message into the dealer, that is totally protected because you've now received the operative or important opt-in. You now have permission to engage them in conversation until they reply stop. Our system is built so that if somebody replies stop, I can guarantee you a message will not and cannot ever go out to that customer from our system until the customer opts back in. We built it that way. In fact, we've even added a feature where a dealer can opt out for a customer if a customer doesn't understand how to reply stop or chooses not to reply stop of their own and wants somebody else to do it for them. So again, we are very knowledgeable in the area of the law and texting. We know exactly what the law is, and I can tell you this, we definitely have any and all customers and dealers covered in this area. So thanks again, and hopefully you will not be engaged in text marketing and get in trouble like some of these other dealers have in the past. Thanks.